Hello there. This is An Architect Goes to Law School. Today in contracts class, we'll be discussing negotiated contracts. Whether an architecture firm has created and offered, in the legal sense, a proposal for the design project, as discussed previously, a thorough and negotiated contract entered into by the architect and the design client is a best practice. First, it's important to understand that all contracts, even proposals, are negotiated by the parties. Whether there are any modifications or edits depends on the party's desires, but that party is, by definition, negotiating the terms of the contract. Many architects focus on the design and construction documentation involved in their services, letting slip the contract negotiation portion of the business relationship with their clients. While that degree of attention paid to contracts is understandable, it is a best practice for every architect to read and know the material terms of each of their contracts before executing them. Alternatively, an architect can have an attorney review the contract and possibly engage in negotiations on the architect's behalf. To emphasize the point, no party to any contract should be surprised about anything they have agreed to and signed. There are many different formulations for architect project owner contracts, ranging from short ones that may be drafted by the architect to time-tested contracts drafted by attorneys and experts on behalf of and licensed to architect and project owner clients. In contrast with simple design proposals, negotiated contracts should have the following sections and clauses as a best practice. These include, but are not limited to, each party's rights and responsibilities under the contract, scopes of the architect's basic, supplemental, and additional services, payment terms such as amounts and deadlines, dispute resolution processes, termination situations and subsequent actions and responsibilities, and intellectual property clauses. To reiterate, contracts are essential tools in the practice of architecture because they define the parties' rights and responsibilities during a design project and even afterwards. Even the best architect-owner relationship should have contractually defined roles for the parties to increase the odds of a project's success. Such contracts can be drafted by the architect, the owner, outside professionals, or an attorney working with one of the parties. Two examples of third-party contracts are AIA contract documents and consensus docs. When talking about the effort needed to create and enter into a contract, the two major time components are the drafting and the negotiations between the parties. Using a third-party contract, while not perfect for every situation, provides benefits on the parties in addition to potentially saving time. Some of these benefits include court-tested terminology, thoroughness, and ease of use. These form contracts have been revised over the decades in order to better utilize phrasings that have specific meanings in legal contexts. Contract terminology has been defined in the contracts based on court cases. The multiple iterations of these contracts also means that they have been drafted to include many different possibilities and eventualities in design and construction projects. In contrast with simplistic design proposals, these form contracts contemplate many complex aspects of the design endeavor. Finally, because they have already been drafted for one's use, in addition to saving time, they are usually easy to read by an architect or project owner who then fills in the blanks. One example of form contracts is AIA contract documents. The American Institute of Architects has promulgated standard contracts since 1888. As of 2025, there are 276 different documents in the AIA Contract Documents Library. These are available for license and use by architects, project owners, contractors, among others. Another example is consensus docs. This family of third-party contracts and construction project documents has been drafted by professionals, including lawyers, to, quote, incorporate fair risk allocation and best practices to represent the project's best interests, end quote. These documents are intended to be more balanced than other form documents. There are approximately 115 documents in the Consensus Docs library with yearly subscription offerings for a full package, for designers, and for subcontractors. Feel free to comment, ask questions, and suggest topics you'd like me to discuss. Next up in contracts class, we'll discuss changes to the contract. Thank you for watching An Architect Goes to Law School.